All right, let's go on the record on cause number DC 21-14795, Lindy Rush versus Texas Department of Transportation et al. Council, make your appearances.
Yes, Neil Flagg, appearing on behalf of the plaintiffs.
Hunter Alston for defending K-Bar Services.
All right, we're hearing a motion for leave. You may proceed.
Yes, Your Honor. This is the defendant's motion. We're here today to ask the court to grant its motion for leave to designate a responsible third party, a John Doe unknown driver that prevented Mr. Rush, the deceased in this case, from re-entering I-35 as identified by plaintiffs in their petition and by the Carrollton Police Department in their crash incident report. Addressing the merits of this motion, Texas Rule of Civil Procedure Section 33.004J sets out the requirements for designating an unknown responsible third party. Under Section J1, the defendant must have pled sufficient facts for the court to determine with a reasonable probability that the act of the unknown person was criminal. J3 notes that the pleading requirement standard is the same as the Texas Rules of Civil Procedure, which is a liberal, non-stringent pleading standard. All that is required is for there to be a fair notice based on the pleadings. Here, Your Honor, K-Bar Services has pled sufficient facts in its motion and amended answer to ascertain that John Doe drove recklessly without regards to others on the road, like Mr. Rush, and left the scene of the accident without rendering any aid or giving his personal information despite there being an injury or a high likelihood of death with this incident. And those are violations of sections of Texas Transportation Code. K-Bar Services pled as well as plaintiffs themselves in their petition that John Doe prevented Mr. Rush from re-entering the highway, which caused him to impact the attenuator and the median and the injuries that followed after. K-Bar Services complied with J2 section as well by including all identifying information of John Doe as known by the defendant.
Isn't the main issue here just it's a timeliness issue that you guys waited more than 60 days after the filing of the original answer?
Yes, Your Honor. Addressing the timeliness, that is true. We filed our motion 90 days out from our original answer, opposed to the 60 days required. However, the court should look past this in the interest of fairness, because the plaintiffs shouldn't be surprised by this motion and they won't be unfairly prejudiced, and K-Bar Services won't be granted any type of strategic advantage that the legislator hoped to avoid by the designing of this rule. Plaintiffs themselves have pled to the existence of John Doe and his involvement in the collision since before K-Bar Services was a party of this lawsuit. Furthermore, TxDOT and K-Bar Services have both included John Doe as a potential third party in their initial disclosures served on December 31st, 2021 and September 13th, 2022, respectively, by both parties. Likewise, defendants will not have gained any type of unintended strategic advantage here because plaintiff statute of limitations has not yet run, which is typically looked at in other areas of the rule, such as Section D for indication for plaintiffs being prejudiced, and the trial is still some 200 days away. Finally, plaintiffs will not be prejudiced because they still have an opportunity to strike this motion through subsection L after an adequate time for discovery has passed, Your Honor, if this motion is granted today. So they can still get this motion or this indication strict if need be.
Response?
Yes, Your Honor. Good morning. This is a wrongful death premises liability case involving the hazardous condition created on Interstate 35 when a crash cushion was left unrepaired for over 11 days and where no warnings were provided to motorists of the defect or the hazardous condition. Court correctly pointed out plaintiff's main objection to the motion, and that is that according to the express rule and the specific rule related to the joinder of unknown persons as responsible third parties, that it must be done within 60 days from the filing of the original answer. In this case, it was not done. I've cited the Gonzalez case in my response, which clearly shows that and indicates it's a Supreme Court case back from 2021, and it expressly says that that rule overrides any other rule related to unknown persons, and that the 60-day time requirement is exactly what it is. I've also cited in my, or argued in my response, that even if the court decides that the 60-day requirement can be somehow waived, which we don't think it can be, that
is there any case law about this that says that you can extend the 60 days? Because the statute seems to be kind of, it's mandatory, but is there any case law, Mr. Ralston, that you've seen that extends the 60 days?
Not for Section J, Your Honor. Section D, they've extended it based off of the initial disclosures, but not for Section J. I haven't seen any case law on that, Your Honor.
I don't know that I have any, unfortunately, any discretion here, absent guidance from the Court of Appeals. So let's see. Did you submit an order on this, Mr. Flagg?
I did. If I need to.
What do you know? What? Let me see what day you submitted it.
Same day I filed the response. I think it was December the 8th.
I see it. Yeah.
Okay.
Okay. All righty. You guys have a great rest of your day. Okay. There's somebody signing on. Is Mr. Lebinger on this case?
No, Your Honor.
No, Your Honor.
Okay. And then he signed off. Okay. That's it, guys. You guys have a great rest of your day.
Thank you, Judge.
Thank you, guys.
Thank you.